This is an evidentiary hearing before the Indiana Utility Regulatory Commission in the cause docketed before the commission as cause number 38703, FAC 143, captioned as Application of Indianapolis Power and Light Company doing business as AES Indiana for approval of a full cost factor for electric service during the billing months of June 2024 through August 2024 in accordance with the provisions of Indiana Code 8-1-2-42, continued use of rate-making treatment for cost of wind power purchases pursuant to cause numbers 43485 and 43740, and continued recovery of the cost of the full edging plan pursuant to Indiana Code 8-1-2-42. Notice of the time and place of the hearing was given as provided by law by publication in Marion County in the Indianapolis Star on March 26, 2024. This is a newspaper of general circulation, and this publication was made at least 10 days prior to the date of the evidentiary hearing. The proofs of publication of the notice has been received by the commission and is now incorporated into the record of this cause by reference and placed in the official files of the commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. May we have appearances, please?
Thank you, Your Honor. On behalf of the petitioner, Indianapolis Power and Light Company, doing business as AES Indiana, Teresa Morton Neihart and Jeffrey M. Peabody with the law firm of Barnes & Thornburg, LLP, 11 South Meridian Street, Indianapolis, Indiana.
On behalf of the public, Lorraine Hitz, Indiana Office of Utility Consumer Counselor, Indianapolis, Indiana.
Thank you. Will all who know themselves to be witnesses in this cause please stand? Please raise your right hand and be sworn. Do you swear or affirm the evidence you will give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you. Petitioner will proceed.
Thank you, Your Honor. At this time, the petitioner would call Ms. Natalie Koklow to the stand. Good afternoon, Ms. Koklow. Can you please state your full name and business address for the record?
Natalie Herr Koklow, 1 Monument Circle, Indianapolis, Indiana, 46204.
By whom are you employed and in what capacity?
I am a manager in regulatory accounting by AES US Services, who is the service company that services AES Indiana.
Do you have before you a document that has been marked for identification purposes as Petitioner's Exhibit 1?
Yes, I do.
And is Petitioner's Exhibit 1 your direct testimony which you reduced to writing and had filed in this cause?
Yes, it is.
And does Petitioner's Exhibit 1 include your attachments NHC1 through NHC4?
Yes, it does.
Do you also have before you what has been marked for identification purposes as Petitioner's Exhibit 2?
Yes, I do.
And is Petitioner's Exhibit 2 your rebuttal testimony, which you reduced to writing and had filed in this cause?
Yes, it is.
Were these exhibits prepared by you or under your direction and supervision?
Yes, they were.
Do you have any changes to your direct or rebuttal testimony?
No, I do not.
Do you adopt these exhibits as your sworn testimony in this cause?
Yes, I do.
Your Honor, the petitioner would offer into evidence petitioner's exhibits 1 and 2.
No objection.
Thank you. Petitioner's exhibits 1 and 2 are admitted. Thank you. Petitioner's exhibits 1 and 2 are admitted into the record.
Thank you, Your Honor. The witness is tendered for cross-examination.
May I proceed?
Thank you. Good afternoon, Ms. Kokolo. Thanks for coming.
Good afternoon.
I'm going to ask you to turn to your rebuttal testimony. Turn to page 2, if you would.
Okay.
At question 6, you're discussing OUCC witness Mr. Garatas's recommendation to remove the contract amendment costs from the FAC. Is that correct?
Yes.
And as I understand your answer, Mr. Garatas is asking for that cost to be removed from the FAC. Is that correct?
I'm not sure I heard your question there. Sorry.
Maybe because I didn't ask it very well. Mr. Garatas's recommendation is that this, I don't want to say that number, is that confidential, counsel?
Yes.
Yes, Your Honor.
Okay. Then the dollar amount, which will remain confidential, it is contained within AES's work papers, that amount of money should be removed as it is not a fuel cost. Is that correct?
I believe Mr. Garatas is saying that he believes it's not fuel costs associated with the cost of managing and maintaining reliable fuel supply and inventory.
Okay, and you cite Mr. Garatas's testimony on line 10 that it is not a fuel cost incurred to generate electricity. Is that correct?
Yes, that's his statement.
Okay. And you disagree with that. You believe that it is a fuel cost, as stated on lines 13 and 14. Is that correct?
Well, lines 13 and 14 is quoting Mr. Cooper's testimony.
Right. You're challenging that position. You do believe those costs are fuel costs. Am I correct?
My testimony surrounds the proper accounting treatment of those costs and shows evidence that, based on that proper accounting treatment, that the Commission has previously ruled that costs includable in FERC 151 are in fact recoverable in the FAC.
Your Honor, I would move to strike everything after the simple yes or no that I requested.
Your Honor, I believe the witness is just trying to explain her answer and respond to Ms. Hitz's question.
And I believe that the question that I asked called for a yes or no answer, not a further explanation of what her testimony says or does not say.
That is okay. You may proceed with your next question. Sustain. Please limit your answer to the questions being asked. Thank you.
Thank you, Your Honor. Ms. Koklo, just to make it easy on both of us, since we can't discuss the actual dollar amount, I'll just describe it as X dollars.
Okay.
To be clear, the X dollar amount that AES wants to recover as a fuel cost did not buy coal. Is that correct?
The contract, this is a contract amendment, and that contract did buy coal.
Did the payment that AES made that the OUCC is recommending be disallowed result in AES getting delivery of coal?
I believe so. That's what the contract was for in its entirety.
Now, I'm specifically asking Ms. Koklow, the X dollars that the OUCC wants to exclude, did that result in coal being delivered to AES?
I would say yes, and I also think your question is better covered by Witness Cooper's testimony.
So even though the X dollars was to buy out the contract, you're saying that coal was actually delivered? Is that correct? For that amount of money?
Your Honor, I'm going to object that the question's outside the scope of Ms. Koklow's testimony, and it's addressed by Mr. Cooper.
All right, I mean, I certainly can ask Mr. Cooper that question, but this is relevant to Ms. Koklow's rebuttal. I'll move on. So you're arguing that the X dollars should be recoverable as a fuel cost under the FERC Uniform System of Accounts, where I'm now moving to page 2 and 3 of your rebuttal. Is that correct?
Yes.
And specifically on line 2, you're referring to FERC account 501, and then in the next line, you're referring to account 151. Is that correct?
Yes, I just discussed both FERC accounts.
Okay. May I approach, Your Honor?
Yes, you may. Let's go off the record.
Amy, while we're off, is 151 CX1 or 2? I'm sorry. So in the middle of the page, it says 151. Thank you so much. Apologize, I didn't.
We go back on the record.
Thank you, Your Honor. Ms. Koklo, do you have what have been marked as OUCC CX Exhibits 1 and 2 in front of you?
I do.
And are these excerpts from the Uniform System of Accounts, the FERC Uniform System of Accounts that you make reference to on page 3?
Yes, they appear to be.
Thank you. Now, let's turn back to your rebuttal testimony. On page 3, you cite to a commission order from lines 5 down to 24, discussing what FACs contain and how certain terms are defined. Is that correct?
Yes, I cite a specific IURC order.
All right. And can we just clear up for one issue right now? For on line 19, it references account 518. Can we agree that those are nuclear costs that don't bear on this case?
Yes.
Thank you. So your reference here to this order, on line 12, it says that the FAC should not include any cost not directly applicable to the acquisition of fuel. Do you see that there?
Yes.
When AES made the payment of the X dollars, did it actually acquire tons of coal?
I believe that question is better suited for Mr. Cooper.
Well, you are testifying here that this is how FAC costs are calculated and defined, are you not?
I'm testifying that these costs are properly includable in FERC 151, and that historically, the IURC has adopted costs allowed in the FAC if they are recorded in account 151.
Your Honor, again, I would ask that Ms. Koklo's answer be stricken after the yes or no. It was a simple question. I don't want the history of what the commission may or may not have done.
Your Honor, the question was directed to what Ms. Koklo's testimony was stating, and Ms. Koklo was explaining what her testimony states.
Overruled. Thank you.
Your Honor,
Overruled. Thank you.
I'm going to ask you at this point, Ms. Koklo, to turn to what's been marked as OUCC CX1. Again, that is the excerpt of the FERC Uniform System of Accounts for fuel stock, or account 151. Can you identify for me on those 2 pages where contract buyout falls into the cost of fuel?
First, I believe it falls under 1, invoice price of fuel. These costs were in fact invoiced from our coal company. Secondly, item number 3 also lists other expenses directly assignable to the cost of fuel.
The X dollars paid by AES, it is your testimony that fuel was purchased by those dollar amounts. Is that correct?
It was a fuel contract.
Ms. Koklow, my question was, did fuel result in inventory for AES as a result of the X dollar payment?
I believe it is an inventory cost, yes.
Your Honor, I would ask that the witness be instructed to answer the question that I asked.
Your Honor, I believe the witness is attempting to answer her question and explain her understanding of what the account allows for and the nature of these costs that were incurred.
And Your Honor, my question was, did the dollar amount result in actual inventory to AES? That is a simple yes or no answer.
Sustained. Please answer the question that's been asked. Thank you.
I don't believe your question is easily answered with a yes or no. This is a fuel stock account, and it lists many things, such as insurance and depreciation on railroad.
Your Honor, again, the question was, and I am asking Ms. Koklow again, did the dollars paid by AES result in the delivery of fuel inventory to AES?
Your Honor, the witness is attempting to answer Ms. Hitz's question, which she has explained is being too narrowly construed.
The question has been asked and answered. Thank you.
Your Honor, please note my objection for the record. I don't believe that it was, in fact, answered. Let me move on. Oh, no.
Can we go back on the record, please?
Thank you, Your Honor. Ms. Koklow, before we were interrupted, could you turn over to page 4 of your rebuttal? And at the top of page 4, from lines 4 to 12, you're describing what is included in account 151. Is that correct?
Correct.
And if you turn to your copy of 151 that we had put into the record, or you have in front of you, it has not yet been offered into evidence. Would you take a look at number 2 on the description of account 151 on the exhibit, the cross-examination exhibit, please?
So you're referring to, it says 67 at the bottom, the cover of the 151, Exhibit 1?
Yes.
Okay, I'm there.
Cross-examination exhibit 1, it's marked as page 76 on the bottom right corner. And if you look at item number 2, you have that described in your testimony at line 5 on page 4 as freight, switching, demurrage, and other transportation charges. Would you agree with me that the FERC document describing account 151 also states, not including, however, any charges for unloading from the shipping medium?
I see that on your document. I took the items in 151 directly from the FERC's website, so I'm not sure.
Well, then I'll have to have
Why
a
there's
word
a
with
difference?
Westlaw, because obviously they don't have the most recent version. Or I'll check with FERC. Thank you. On line 14, you describe the X dollars as the coal contract amendment costs. And when that contract was amended and that payment was made, has AES received any additional coal from Peabody since that time?
I am not sure.
Now, on page 5 of your testimony on your rebuttal, you make reference to FAC 111. Do you see that reference there?
Yes, I do.
May I have a moment, Your Honor?
Can we go off the record, please?
I apologize. When we left for the fire drill, I turned everything over, and now it's out of order. I'm ready. Thank you.
Can we go back on the record? Thank you.
Now, you make reference to FAC 11 and the discussion by AES in that case that the system-wide coal inventory was above maximums and that AES took efforts to store or defer costs because of the reduction to the expected coal burn. Is that correct? From lines 8 down to 10 on page 5 of your rebuttal.
I see the discussion of storage. I don't think storage was an option actually chosen in that case, that I
agree.
remember.
Yeah, I'm just kind of focusing
Okay.
you there.
Okay, I'm with you.
And you also reference coal contract buyouts on pages 11 to 12.
Yes,
I'm
I
sorry,
see that
lines
term.
11 to 12. Isn't it the case that, in fact, there was no coal contract buyout in that FAC 111?
I believe that to be true, yes.
And turning over onto page 6, when you show the commission's language on the use of the coal decrement from lines 3 down to 9, your language taken from the FAC 11 order does not refer to paying an amount not to take coal, does it?
It does not, but it was presented as an option. We always stack the options to show what's the best cost savings to customers.
But the commission decision in that case did not approve AES to pay not to take coal, did it?
That order focused on what we chose at that time, which was decrement pricing.
Thank you. And you make reference also on the following page, your rebuttal, page 7. In FAC 115, you talked about coal inventory management, including reclaiming coal at Harding Street in Eagle Valley. Is that correct?
That's part of the discussion, yes.
And that case included a settlement, did it not? Your testimony even
It
makes
included
reference.
a settlement, but it wasn't related to whether the costs were properly recovered, but over what period of time they would be recovered.
Are you aware of the commission's policy on the citation of settlements, Ms. Koklow?
I'm not a lawyer, so I'm not sure what you're referring to.
Or are you aware that the FAC 115 order specifically contains language that the order should not be cited as precedent? Your Honor, may I approach?
We go off the record. Yes, go ahead.
Can we go back on the record?
We go back on the record. Thank you.
Ms. Koklow, I've just provided you with a copy of the order in FAC 115. It is my understanding that counsel has access to that document. Is that correct?
Yes.
Okay. I have pointed out to you a footnote in that document. Have you read it?
I read this order, yes.
Did you read the footnote that I pointed to you when I handed you the document?
Yes.
And does that footnote say that that the order is not to be cited as precedent?
It says, in addition, with regard to the future citation of the settlement, our approval should be construed in a manner consistent with our finding in Richmond Power and Light, cause number 40434.
You are not aware of what that means then? The citation, never mind, withdrawn. So, having gone over the cases that you cited, none of the cited cases involve a situation where AES paid money but did not receive coal. Isn't that correct?
The FAC 115 does deal with coal that was not used to generate electricity.
And as we just discussed, that case was a settlement. Is that correct?
It had a settlement, yes.
Thank you. And the facts of that case involving the settlement were that there was waste coal. Isn't that correct?
I would refer to it as unrecoverable coal at the bottom of the
Right.
pile.
Right. Thank you. I have no further questions. Let me just say, at this time, we'd offer what have previously been marked for identification as OUCC's cross exhibits 1 and 2 into the record.
Any objections?
No objections, Your Honor.
Thank you.
The public's exhibits 1 and 2 admitted into the record. Thank you. The public's exhibits 1 and 2 admitted into the record.
Thank you, Your Honor.
Correction, public's exhibits CX 1 and 2 admitted into the record.
Thank you, Your Honor.
Can we have a minute, Your Honor?
Can we go off the record?
Ms. Koklow, I'm going to take back my copy of it.
This one?
I'm ready for a couple of redirect questions, Your Honor.
Can we go back on the record? Petitioner may proceed.
Thank you. Ms. Koklow, you were asked a question by Ms. Hitz related to the FAC 115 order, and she had asked you about a footnote in that that discussed it being settled. And I'm looking at your rebuttal testimony on page 7, line 19, going to page 8 on lines 1 and 2, where you say, while this issue was settled, I would note this settlement was not related to whether the coal management costs were properly recovered through the FAC, but rather how they would be recovered. Just so I can understand, are you relying on the settlement in that case for your testimony in this case?
No.
Ms. Hitz also asked you about the discussion in FAC 111. Do you recall those questions?
Yes.
And in particular, she talked about a quote that is on page 6 of your rebuttal testimony on lines 3 to 6, where the Commission's FAC 111 order said that the record shows that IPL's coal inventory is above target levels and that it has already taken significant actions to actively manage the inventory, including contract minimums and renegotiating its existing coal contracts. So was that order only about coal decrement pricing?
No, there was discussion of various inventory management options.
And then do you recall Ms. Hitz also asked you about the quote you have in your testimony about FERC account 151, which is on page 4 of your testimony, lines 4 to 12. And then she compared your description of account 151 to, She compared your discussion of item number 2 for account FERC 151 to the language she provided in OUCC cross-examination 1. Do you recall that line of questions?
Yes, I do.
And in particular, Ms. Hitz pointed out that in her cross-examination exhibit, number 2, item number 2 under FERC 151 included additional language that said, not including, however, any charges for unloading from the shipping medium. Does that additional language change your position regarding the accounting treatment of the costs in this case that are being challenged?
No, it does not. In my testimony, I cite item number 1 and item number 3 as why it would be includable in FERC 151.
Nothing further, Your Honor.
Thank you. The witness is excused. Let's go off the record. You may call your next witness.
Thank you, Your Honor. Petitioner would call Ms.
My apologies. May we go back on the record? Petitioner, you may call your next witness.
Thank you, Your Honor. The petitioner would call Mr. Aaron Cooper to the stand. Good afternoon, Mr. Cooper. Can you please state your full name and business address for the record?
G. Aaron Cooper, 1 Monument Circle, Indianapolis, Indiana, 46204.
By whom are you employed and in what capacity?
I'm an employee of AES U.S. Utilities. I'm the Chief Commercial Officer for the U.S. Utilities.
Do you have before you what has been marked for identification purposes as Petitioner's Exhibit 4?
Yes.
And is Petitioner's Exhibit 4 your rebuttal testimony which you reduced to writing and had filed in this cause?
Yes, it is.
Do you also have before you a document printed on green paper and marked as Petitioner's Exhibit 4C?
Yes, I do.
And is Petitioner's Exhibit 4C your confidential attachment and work paper?
Yes, it is.
Were these exhibits prepared by you or under your direction and supervision?
They were.
Do you have any changes to your rebuttal testimony?
I do not.
Do you adopt these exhibits as your sworn testimony in this cause?
I do.
Your Honor, Petitioner would offer into evidence Petitioner's Exhibits 4 and 4C.
No objection.
Thank you. Petitioner's Exhibits 4 and 4C admitted into the record.
Thank you, Your Honor. The witness is tendered for cross-examination.
Good afternoon, Mr. Cooper.
Good afternoon.
Let's turn to your rebuttal, since you did not file direct testimony in this case. Is that correct?
I did not file direct testimony.
Okay. Turning to page 3 of your rebuttal, focusing on the answer beginning on line 8. You're responding to Mr. Garitas's testimony to, as you say, remove the coal contract amendment cost, also referred to as the contract buyout from this FAC. Do you see your testimony there?
I do see my testimony.
Now, the coal contract buyout, were you required to make the payment in this case? Did you hear me refer to the dollar amounts as X dollars to avoid the confidential number?
Yes, if the question is, I heard that we're going to refer to it as X amount, yes.
Okay. Were you required to pay the coal company X dollars not to take coal?
We were required to pay the coal company to amend the delivery obligation under the contract for 2023.
And did that amendment result in any additional inventory, fuel inventory, from the coal company to AES after that amendment was entered into?
As I said in my last response, the payment and the amendment were to alter the contractual obligation for tons under that agreement for the calendar year 2023. And we did deliver all of the coal that the amended contract quantity required.
When you say did you say you delivered the coal?
We amended the contract volume, and we delivered the amount of the remaining contract volume.
And when you say delivered, where was that delivered?
The coal under the subject contract was delivered to the AES Petersburg plant. To be clear again, what I said is that the contract had an original quantity. The amendment that we're discussing reduced that quantity, and my response is that we delivered the quantity that we were obligated to deliver under the contract after the amendment.
And with the payment of the coal contract amendment costs, or the payment to alter your contractual obligation, did that result in additional inventory being delivered?
Your Honor, I'm going to object as asked and answered. Ms. Hitz just asked a question whether that cost resulted in additional fuel inventory. It's the same question.
I'll rephrase.
Thank you.
Was that payment to the coal company made because AES wanted to defer additional coal delivery?
The payment in question was to reduce the amount of coal that we would be required under the contract to deliver to the plant in 2023.
And was that reduction down to 0 tons?
It was not.
When you made the payment of X dollars, what inventory did that payment cover?
The payment changed the amount, the total quantity required to be delivered under the contract.
What did it change it from and to?
Your Honor,
Go ahead.
just want to object to the extent this gets into confidential information. I just want to be mindful of that before Mr. Cooper answers.
Is there a way that you can answer that question, Mr. Cooper, that would not reveal confidential information?
I don't believe that there's a way that I could answer it in a specific way that would not reveal confidential information.
Your Honor, I would ask that we go into camera so that Mr. Kubik can answer the question, please.
May we go off the record?
So when you paid the coal company the X dollars that we just discussed while we were in camera, that was to amend the contract and take less coal. Correct?
That is correct.
By reducing the amount of coal then, when you made that payment, you did not, let me rephrase that. I know what I mean to say, but if you have reduced the amount of coal, so you're paying not to take coal, and you therefore have a coal pile and then not a coal pile, you can only generate electricity from the coal. Is that correct? It may seem overly simplistic, but.
It does require coal to generate electricity at a coal plant.
Thank you. May I have a moment, Your Honor?
Here we go off the record.
Thank you, Your Honor.
We go back on the record, please.
Mr. Cooper, if you could turn to page 6 of your rebuttal testimony. You refer to, on line 10, AES Indiana following its fuel policy that had been previously approved in the commission order in your FAC 133. Do you see that there?
I do.
And that fuel policy is part of your confidential attachment, is that correct?
Yes.
So we won't discuss the details of that. Does AES's fuel plan, their fuel policy, override statutory requirements?
AES's fuel policy is meant to observe any requirements that we have in that regard.
And on that same page, you make reference to FAC 142, AES's testimony in that case of Mr. Jackson at the bottom of page 6 of your rebuttal and carrying over to page 7. Is that correct?
I do make that reference.
All right. And when you turn over to page 7, from lines 12 down to 14, states, since our last FAC, we have completed amendments to defer tonnage as well as canceling some of the coal shipments for a cost. Do you see that there?
I do see that passage.
Right. Did the commission approve cancellation of coal shipments for a cost in FAC 142?
I quote the order in lines 26 through 30, and it says that the record shows applicant has and continues to take reasonable steps to manage its coal inventory during changing coal market conditions. The record further shows applicant's Current coal inventory, while above target levels, will continue to be monitored and inventories managed to ensure reliable coal supply.
But none of that language specifically says that AES may recover costs for canceled coal, does it?
It does not explicitly approve the actions taken to manage our coal inventory, but it acknowledges that actions are being taken. And I would go on to say it identifies them as reasonable steps.
Well, it does, the language does not say that canceling coal deliveries is reasonable per se, because you didn't present the issue in FAC 142, did you? You didn't ask for costs for canceling coal in FAC 142.
FAC 142 was not for the subject period.
What do you define as a subject period, Mr.?
The reconciliation period for the months covered in FAC 143.
Okay, so to be clear, AES did not request coal contract amendment costs or contract buyout costs before FAC 143.
AES Indiana continued with its practice of being very transparent in our interviews with the OUCC and raised the issue to provide the opportunity for feedback, and none was received suggesting that it would be opposed or that it was imprudent or inappropriate.
Well, the OUCC raised it as an issue in this FAC, though. Isn't that right?
Yes, it has.
And this is the first time that AES has requested recovery of such costs in an FAC. Is that correct?
Based on the information I understand, while other coal amendment costs have been approved in prior FACs, this specific instance was not ever addressed in a prior FAC.
When you say this specific instance, do you mean coal contract buyouts?
I am not specifically aware of any coal contract amendments changing tonnage obligations in this way to have been addressed in prior FACs for AES Indiana.
Thank you. If you look at page 11 of your rebuttal, on line 35, you state you're arguing that the evidence in this FAC presents no legitimate basis for the commission to attempt to reverse its decision in FAC 142 that the D1 test had been satisfied. But again, there was no issue of coal contract amendment costs in FAC 142, right?
In the language at line beginning at 17, if my eyes don't fail me, it says, he said since applicant's last FAC, applicant has completed amendments to defer tonnage as well as canceling some of the coal shipments for a cost.
I see that.
it seems to us, seems to me, that there was an opportunity at that time to address the issue, since we were, as I said, transparent and forward-looking in our explanation of the options that we were considering and what ultimately was the best decision for our customers that reduced their costs by over $1 million.
Okay, but the actual dollar impact of canceling some of the coal shipments for cost did not actually get included in a factor calculation until FAC 143, correct?
Due to the timing and the periods covered in FAC 142, there was not a reason that the coal amendment costs would have been included in FAC 142.
So the answer to that question is yes.
Honestly, I would need you to re-ask the question. I'm not sure what I would be answering yes to.
That's fine. Just have a couple more questions. I swear I'm almost done. Page 14, on line 4, you're talking about the various choices about how to deal with excess inventory. And you make the statement there that there were no third-party bids for the coal. Were there any bids for the coal?
In the strictest sense, the answer to that would be no. We did not, we through various direct and broker channels, tried to find a market to sell that coal. As stated in my testimony, as it continues there on lines 5 and 6, we negotiated an amendment with the supplier to reduce the tonnage.
Okay. But when you say there's no third-party bids, why do you use that qualifier? Were there bids from within AES?
Because of the complication of related party transactions, we did not attempt to find another home for the coal within AES.
Okay, thank you. Turning to page 17 of your testimony, you're talking there about a particular FAC 38709 FAC 41, which was a Wabash Valley Power Association case, and using that as support for your position. Isn't it true that in that case, Wabash Valley was presented with retroactive billing from PSI, now known as Duke, because of a FERC decision? What I'm trying to say is this is a distinguishable situation. It is not the same set of circumstances, is it?
The order explicitly addressed buyout costs related to coal.
That was pursuant to a federal order, isn't that correct?
I do see, well, I don't know what the original pagination would have been. This is from Westlaw, but I do see that the Gibson Station coal contract buyout cost was associated. The retroactive billing was related to an FERC order.
Thank you. I have nothing further. Thank you, Mr. Cooper.
We have a minute, Your Honor.
You will go off the record.
I'm ready, Your Honor.
Let's go back on the record.
Mr. Cooper, Ms. Hitz asked you a number of questions about the quantity of tons of coal the company received. Can you explain why the company amended the contract?
There are a number of things I would address in that regard. Of course, first, we addressed in my testimony that we had concerns regarding the inventory and the safety of our employees and being able to continue to provide reliable, safe power for our customers at the reasonable least cost possible. We also did the amendment because, as we showed in my testimony, we considered a number of alternatives to address those inventory issues and contemplated ways that that could be done, including, I'll run back through the list. It's very common that utilities do this kind of evaluation, decrement-based pricing to increase the burn, deferring coal to a later period in time, storing coal off-site, which I explained earlier was not a viable option, but despite that would have been a very expensive option in this case. And the best value for our customers was to, as we did, amend the contract to reduce the tonnage that was delivered for calendar year 2023, which had the result of saving customers over $1 million as compared to if our other viable alternative would have been decrement burn, which would have had a higher cost.
You mentioned safety. Can you explain why safety was an issue?
As I mentioned in my rebuttal testimony, from the time that we entered into the contract until the delivery year, because of market factors, burns were reduced by about 1.6 million tons. And we, as a result, in fulfilling our contractual obligations and exercising every option that we had within contracts to reduce tonnage, we nonetheless arrived at a point where we were no longer able to put coal in the pile and safely manage the pile, which is, of course, an important factor or element of generating power.
Ms. Hitz had asked you a question about the coal pile and whether the amended contract eliminated the coal pile. Can you explain how the amended contract relates to the coal pile?
Your Honor, I have to interject here. I don't recall ever asking if the contract amendment changed the coal pile.
Your Honor, she had asked a question where she said you had a coal pile, then you amended the contract and you didn't have a coal pile. I'm just trying to clarify for the record the impact that the amended contract had on AES Indiana's coal pile.
And Your Honor, just to clarify, I was not speaking of the coal pile. I think I was making the analogy of there's some coal and then there's not coal.
Which is why I'd like to have the witness clarify for the record what exactly we're talking about here.
Okay, fair enough.
Yes, as I said in my rebuttal testimony, we had reached the safe limits of our pile size. I won't mention here the specific tons. We have included in our testimony, in the direct testimony in the FAC, not mine, that we were above our targeted levels. And our coal pile had, which are 25 to 50 days of inventory, which we've also said publicly. We were well above that, and we had reached the safe limit of our ability to put any additional tons of coal on the pile. So we absolutely maintained a very robust coal pile during this action.
Your Honor, I wanted to go in camera for maybe a question or two, just out of an abundance of caution.
Here we go in camera.
Mr. Cooper, Ms. Hitz asked you a number of questions about paying X dollars to amend the contract. Do you recall those lines of questions?
I do.
Can you explain why it might be reasonable to pay more per ton to amend a coal contract?
Yeah, there are a number of reasons that it might cost more to amend the contract. It changes the economics for the supplier, of course. It might reflect the value of coal at a particular point in time when the amendment is being made. And I suppose there are other reasons that one might pay more to do that. Similarly, one would expect to pay to defer tons for a later delivery. Generally, in circumstances, particularly as in this case where the current coal market is lower than the market was at the time the original contract was signed, anything that increases flexibility or in this instance would result in less tons being delivered might result in a cost increase under the contract.
Nothing further, Your Honor.
Thank you. The witness is excused. May we go off the record?
Your Honor, I do have two more exhibits to put into the record for our other witness. It was going to be the fire alarm again. It's like, no.
May we go back on the record?
Thank you, Your Honor. At this time, the petitioner would move to admit what has been marked as Petitioner's Exhibit 3, Mr. Dickerson's direct testimony, including his attachments AD 1, 2, and 5, and Exhibit 3C, Mr. Dickerson's confidential attachments AD 3, AD 4, and AD 6.
Any objection?
No objection.
Thank you. Petitioner's Exhibits 3 and 3C are admitted into the record.
Thank you, Your Honor. Nothing further.
The public may proceed.
Thank you, Your Honor. At this time, I'd offer what's previously been marked for identification as the following. Public's Exhibit Number 1, the testimony of Gregory T. Garitas, and Public's Exhibit Number 1C, the confidential testimony of Mr. Garitas, and Public's Exhibit Number 2, the testimony of Michael D. Eckert.
Thank you. Any objections?
No objections, Your Honor.
The public's Exhibits 1, 1C, and 2 are admitted into the record.
Public rests.
Thank you. And just to confirm the dates proposed earlier regarding proposed orders, AES will provide its proposed orders on May 16th, which is tomorrow, and we will get OUCC's proposed order by May 21st. Correct. And AES reply will be provided next Friday, May 24th. Is that correct?
Correct, Your Honor.
Thank you. If nothing further, we're adjourned.
Thank you.
Thank you, Your Honor.
Thank you,